Good evening. This side Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting. Today, I would be covering a very important topic. However, I would be speaking as a blend, which means I would be talking as a finance person and I would be talking as a second year LLB student. According to the public information, which is available on the Google, effective financial year 15, I repeat, financial year 15, approximately 14.5 lakh crores, approximately 14.5 lakh crores worth of non-performing assets is being written off in India. It means financial year 15 till financial year 23, which means approximately 8 years. 14.5 trillion INR has been phased out in India. Now, the biggest question here is that as we speak, there are two modes to recover your non-performing assets in India. Number one is definitely the Insolvency and Bankruptcy Proceedings, IBC 2016. Number two is definitely the Securitization Act. Sometimes the financial institutions are using insolvency and sometimes they are using securitization. Sometimes they are using the blend of that. Ladies and gentlemen, one thing which we really need to understand and we really need to appreciate is that the drafting of Securitization and Reconstruction Act is really a wonderful drafting. I always appreciate the drafters of Securitization and Construction Act. Having said that, at a one or two points, there is definitely an interpretation issue, but more or less there is no interpretation issue. Today, I would once again highlighting a very important point pertaining to Securitization Act, which is Section 5. But before that, asset reconstruction companies are created in India and they are registered with Reserve Bank of India under Section 3. Now let me study for you. This is the bare act of the Securitization Act. I repeat, this is the bare act of Securitization Act. This bare act is very useful. Let me tell you that this bare act is having a lot of rules, arbitral tribunals, recovery guidelines, and many important things which we need to study. But more importantly, if I go to Section 3 of this Act, which is the basic foundation of this Act is from Section 3, then this is very, very important. Section 3 covers registration of asset reconstruction companies. No asset reconstruction company shall commence or carry on the business of securitization or asset reconstruction without obtaining a certificate of registration granted under this section, having net own fund of not less than 2 crores or such higher amounts as prescribed by Reserve Bank of India. Provided further that an asset reconstruction company exiting on the commencement of this act, because this act commenced 2002, shall make an application for the registration to Reserve Bank of India before the expiry of 6 months from such commencement, and in spite of anything contained in this subsection, which means non-obstante clause, may contain to carry on the business of securitization or asset reconstruction until a certificate of registration is granted or rejected as the communication be. We also need to understand that Section 5 of the Asset Reconstruction Act is very important. Let me read for you. Section number 5. First of all, section number 5 talking about which is known as acquisition of rights or interest in financial assets, which means that when any financial institution approach asset reconstruction company, create a bid, set up a reserve price, say 100 crores, assuming, then, and suppose XYZ asset reconstruction company bid for that, and suppose they are bidding above the reserve price, for an example. In this eventuality, the acquisition of the right or the interest of the financial asset entering into the picture. Now, I would be talking about straight away section 5, subsection 2, which is if the bank or the financial institution is a lender in relation to any financial asset acquired under subsection 1 by asset reconstruction company, and such asset reconstruction company shall on the acquisition be deemed to be the lender, and all rights of such banks or the financial institution shall vest in such company in relation to such financial asset. Please stress on a word that the legislator stressing on the word deemed, which means as soon as you are acquiring from the lender. So let me give a very simple example. I again repeat, it's an example. Punjab National Bank is selling some assets to ARC, asset reconstruction companies. And these asset reconstruction companies are buying from the lender, which assuming Punjab National Bank. It means the deemed ownership is now in the hand of Punjab National Bank. These asset reconstruction company. Having said that, there is definitely something which we need to consider, which is 15:85 ratio, which means that 15% of the value of the assets which you are acquiring to be paid upfront, while for the rest 85% you can issue SR. By SR I mean security receipt. Ladies and gentlemen, this security receipt is a highly technical topic. And let me tell you, the more we discussed about this topic, the more interpretation issues that come into the picture. But simplistically speaking, security receipt is just like small pieces of a big chunk issued to QIBs. If I reach to section 2A, which is more interesting, if the bank or the financial institution is holding any right, title or interest upon any tangible or intangible asset to secure payment. Ladies and gentlemen, please note that the legislation is using a word intangible assets. Please take a note that, because intangible asset is something really very, very interesting. Tangible could be your bungalow, your car, your land, your plant, your factory, your machinery, which you mortgage, hypothecate to the lender. First of all, I'll take an apologies here because I'm not differencing the difference between hypothecate and mortgage, because there is a wide difference between hypothecation and wide difference between mortgage. That's a separate thing that we feel that both are same, but tactfully speaking both are not same. That's also a very interesting point. So if a bank or a financial institution is holding any right, title or interest upon any tangible or intangible asset to secure payment of any unpaid portion of the purchase price of such asset, or an obligation incurred or credit otherwise provided to enable the borrower to acquire the tangible asset or assignment or license of intangible asset, such right, title or interest shall vest with asset reconstruction company or acquisition of such asset. It means like subsection 2 of section 5. I repeat, like subsection 2 of section 5. The subsection 2A also talking about the same thing, which means that the all rights, title, interest, but here the legislator using intangible word also. I would be requesting the legislator, in case my request is considered, to kindly explain the intangible here. Though I understand in the section 2, which is broadly known as interpretation section, in all acts, section 2 is more or less broadly known as interpretation. Sometimes section 1 is known as interpretation. It depends act to act. But I would be requesting the legislator to kindly have a stress on intangible assets, please. And I would be requesting the viewers to kindly check on Google the interpretation of intangible by Honorable Supreme Court of India. Because whenever I am holding any doubt about the interpretation, I use the beautiful services of Google and try and see the interpretation by Honorable Supreme Court of India. Ladies and gentlemen, we need to learn that asset reconstruction companies are playing a very vital role in the economy. There is hardly any doubt. But unfortunately, capital is definitely a constraint. Valuation is definitely a constraint. And today I would be raising another point as far as the asset reconstruction companies are concerned. Ladies and gentlemen, I request the legislator to create a market for asset reconstruction companies, because we need to understand that the non-performing assets are rising in an economy. There is hardly any doubt about that. Writing off the non-performing asset is never be the right solution. But it's beyond my jurisdiction. I would be requesting the legislator to please create a financial market separately for asset reconstruction companies so that they can issue the money from the market, and they can invest these money in terms of buying more security receipts. Like we are having a separate market for commercial paper for corporates. We are having a separate market for certificate of deposits for banks. We are having a separate market of bonds for large corporates. We are having a separate market for treasury bills, treasury notes, treasury bonds, short-term, so on and so forth for RBI. Similarly, I request the legislator to have a separate market for asset reconstruction companies. We need to understand that asset reconstruction company needs heavy financing. Because according to the public information, as of 31st March 2021, I repeat, 31st March 2021, 5.2 trillion worth of security receipts is issued by ARCs. Now, this 5.2 trillion, which I'm talking, it is definitely issued in the form of SR, which is security receipt. And this is 85% portion, because 15% portion is already paid upfront. So if 85% portion is 5.2 trillion, you know the rest, right? Ladies and gentlemen, if second thing which we need to do is to create a tradable market of SR. So example, today, without quoting any specific name, many stocks in India are being traded. Few are large caps, few are mid caps, few are ultra large caps. And the most important thing is the liquidity pattern, without quoting any specific name. Similarly, we would be requesting the regulatory agencies to please have trading market for SR. Because until otherwise, security receipts comes in public, the liquidity would never happen. But there are many issues pertaining to that. One of the issues is definitely the valuation. One of the issues is definitely the origination. Like we are having issues of origination in ETF, exchange traded fund. Another biggest issue is the volatility. And most important issue about SR is the education. We need to educate the investor that there is something XYZ which is known as SR. And that education should be vested with, that education should be vested with the investors. Henceforth, ladies and gentlemen, in this video, we try to cover section 3, we try to cover section 5 and few important aspects about security receipts. More videos would be on the card. Thank you very much. This is Rahul Magan from Treasury Consulting. You have my number 9899242978.